Hello, my name is Benjy of Benjy Law Corporation. We're a full-service litigation firm and we provide labor and employment work. Today I'd like to talk to you about apartment buildings and the obligations of the owner of an apartment building to the manager of the apartment building. In California, if you own an apartment building that has 16 or more units in it, you are obligated by law to have a responsible person reside there. In many cases, that responsible person ends up being the apartment manager. And the law has already determined that the apartment manager is a non-exempt hourly rate employee of the owner. That means that the apartment manager is not an independent contractor. It also means that he or she is not a salaried exempt employee. Stated otherwise, the apartment manager is an hourly employee that receives minimum wage or higher on a per hour basis for services rendered. And that means that the landlord is subject to minimum wage laws, overtime laws, and a slew of other rules and regulations that pertain to employment. Now, under California law, where you have a resident manager living in your apartment complex, if that apartment complex has 16 or more units in it, that resident manager's rent for the manager's quarters is strictly controlled by the law. That means that the landlord cannot charge the manager whatever the landlord deems fit. In fact, under the wage order number 5, which applies to this industry, the landlord is capped at about $600 a month as far as the maximum rent that the landlord can charge to that apartment manager for residing in the manager's quarters. This is in part due to the fact that because it is 16 or more units that are in that complex, the law already requires that there be a resident responsible person. And so the manager's quarters are being provided to the manager so that the owner can comply with that law. And as a consequence, because the manager does not have the freedom to live elsewhere, the owner is capped as to how much he, she, or it can charge the resident manager for residing in the manager's quarters. That dollar amount can fluctuate to a higher dollar amount if the owner of the apartment building has 26 or more employees, which is rarely the case, sometimes, but not always. Or if the manager, or the resident manager in this case, is not just one person, it is a couple, in which case it'll be slightly higher than the $600 per month that can be charged. Now, as if that was not complicated enough, it's important to understand that that approximate $600 amount maximum capped rent that can be charged to the manager for the manager's quarters can be deducted by the landlord as a credit against the hourly wages that have been earned that month by the manager for services rendered. So, for example, if the manager has earned $750 in hourly wages and we the owner want to credit the value of the apartment, which again is capped at approximately $600 a month, what we would do is we would say, okay, well, the manager has earned wages of $750 less the $600 of free credit for the apartment unit that the manager is residing in. Therefore, the gross salary due and payable is approximately $150 in that example. But in order to do this sort of credit against wages earned methodology, the landlord must have a written, voluntarily executed employment agreement with the resident manager that clearly spells out the relationship and expressly indicates that going forward, the intent of the landlord is that the value of the apartment unit, the manager's quarters, will be credited against the wage earnings of the resident manager. Without such an agreement, the landlord can have a serious problem in litigation later on. More specifically, the resident manager may sue the landlord, arguing that he or she was not paid the wages that he or she had earned, notwithstanding the fact that he or she resided in the manager's quarters for free for several months or several years. It doesn't matter. If there is no written employment agreement expressing what I just said, then the apartment manager can make that argument and will probably be successful in making that argument. So it's very important to have, at the front end of the relationship, for the owner to have a written and signed employment agreement with that resident manager that expressly states that this resident manager will be an employee, that the rate of pay will be X, that the manager intends to provide that the owner intends to provide manager's quarters to the manager, and that the value of the manager's quarters, subject to the approximate $600 monthly cap, will be credited against wages that are earned that month by the manager. If you have such an agreement, if it's properly drafted, you should be okay as an owner. If you don't, you're really leaving yourself exposed to wage and hour lawsuits for not having paid the minimum wage and potentially not having paid overtime, notwithstanding the fact that you provided the unit to the manager for free, effectively. So the manager can come out really far ahead as an unintended consequence. So it's very important to make sure this is done right. Now, as you might imagine, in higher priced markets like Los Angeles and San Francisco, apartment units can be pretty expensive. And for that reason, many owners are understandably frustrated by the $600 or so cap that's placed on them or imposed on them by law as to how much they can charge or how much they can credit against wages earned for the manager's quarters. That quote-unquote $600 rule, however, only applies where the owner is doing a direct set-off, a direct credit against wages earned before cutting the wage check to the apartment manager. If, however, the owner opts to do it slightly differently, and I'll explain how, then the owner is not limited to approximately $600. Rather, under this other methodology, the owner can charge up to 2/3 of the fair market rent for the manager's unit and credit that against the manager's wages. So if we run an example, let's say an apartment unit is typically $2,700 a month, and that's the unit that's going to be provided to the resident manager by the owner. Under the original methodology we discussed, which is just a direct credit before you cut a check as an owner and give it to the manager for wages, the manager can only charge up to $600 a month for that and credit up to $600 a month for that on a unit that would otherwise rent for $2,700 a month. Under methodology number 2 that we just discussed, however, the manager can say, I'm not going to do a direct credit against the wages. Rather, I will pay the minimum wage on an hourly basis. I will cut a check for the gross wages less the withholdings and deductions and all that stuff. And then the manager will still need to cut me a rental check back for the manager's quarters. But that rental check can only be 2/3 of the fair market rental value of the manager's quarters. So if that manager's quarters is otherwise rentable for $2,700 a month, in an example like that, then the manager would need to turn around and cut his or her own check back to the owner for up to but not exceeding $1,800 a month, 2/3 of $2,700 a month. In this fashion, the owner can take advantage of a legal loophole that would allow the owner to collect more or to get more credit for the manager's unit than otherwise would be available if it was a direct set-off situation. Now, just so there's no misunderstanding, it's important to recognize that regardless of what methodology the owner of the building decides to use with regard to the rent for the manager's quarters, in either instance, the owner is obligated and required by law to have that written, voluntarily executed employment agreement with the manager. Without that, there will be problems regardless of which methodology is used. So please make sure to consult an attorney and have one properly drafted for you, not to just use one you found online, but to actually have an attorney look at it and modify it appropriately and tailor it for you, and then utilize that with your resident managers at the earliest possible opportunity. And you know, in some instances, it may be that you've already had this resident manager for quite some time, and you may not feel the need to rock the boat by going out and asking them to sign one of these things. But better late than never. You're probably still better off complying with the law and getting the manager to sign something like that, even if it's been a while, versus not having one at all. Now, it's also important to know that starting January 1st, 2018, in the state of California, where an employer has 25 or fewer employees, the minimum wage is $10.50 per hour. And just for clarity, if the owner or employer happens to have 26 or more employees, then the minimum wage is $11 per hour. Of course, both of those figures are subject to even higher minimum wage rates that may apply in various counties throughout California. So please take this with a grain of salt. But generally speaking, the main rule across the state is if there's 25 or fewer employees, the minimum hourly wage is $10.50 per hour. Now, if for owners to protect themselves, they're going to want to make sure that the manager keeps accurate hourly records of when they started each day, when they finished, how many hours of work they provided, when they took meal and rest breaks, etc., so that the owner can meet its obligation under the law to keep those records, which should be kept for at least 4 years. And also because those records would help protect the owner in the event there's a future wage and hour lawsuit against the owner, because they would hopefully accurately reflect how many hours were worked, how much money was earned, and could help demonstrate whether or not overtime was properly paid, etc. So it's very important to have, as a condition of the employment, for the manager to keep accurate hours in writing, and then to turn those hours, those documents, over to the owner for safekeeping at each pay period. And then the owner would maintain those records for at least 4 years, because there is arguably a 4-year statute of limitations in some cases. So you want to keep those for at least 4 years. Now, on a related matter, the owner of the building, as employer, has legal obligations to employees, including the resident manager, to reimburse the manager for any out-of-pocket expenses that the manager incurs in furtherance of his or her duties as manager of the building, or work duties, his work duties. So if, for example, the manager has a personal mobile phone, and the owner of the building says to the manager, you need to always have your mobile phone with you so that you can receive calls from the tenants of the building if there's a problem, and assuming the manager complies and does that, the owner needs to reasonably estimate how much percentage of the time that phone is being utilized for work duties. For the sake of argument, let's assume 15% of the time the manager's telephone is dedicated to the manager's work duties as manager of the building. And let's assume that the manager has a cellular phone bill of $100 a month. In that case, the owner of the building has an obligation to reimburse the manager at the rate of $15 a month for every month that the manager is working as manager and using the cell phone. And failure to do that may not seem like a big deal but it actually can be, because it's not only about the $15 a month in this example. Fact is that the law requires this to be done, and if it's not done, subjects the owner of the building to not only having to pay the amounts that were never paid and should have been, but also exposes the owner to having to pay attorney's fees in connection with that, which, as we all know, can be substantially more than just the $15 a month. So it's really important to pay attention to this and to make sure that all reimbursements are timely made.